All right, so we're going to get started so we can get out of here on time because we do have a busy schedule, an agenda for today. So welcome everybody to August. I was going to say July, but it's August.
Yes.
Summer is flying by. I just want to welcome Gary. He is here from the office a lot, and he's going to be doing our presentation on eminent domain. So we're going to start an open session, and then when we discuss properties and things like that, we'll go ahead and move to close.
Before you do that, do you want to approve?
Yes, we'll approve the minutes first. So yeah, I did see that. Sorry. All right. So did everybody have any questions about the minutes from last? It was kind of straightforward.
So sure.
So do you want to make a motion to approve the minutes? Or is that-
Move to approve the minutes from the July 16th meeting.
Second that.
Second, all in favor?
Aye.
Aye, all right. Oh, sorry. It's yes. All right, the minutes have been approved for the July 16th meeting. All right, thank you. So we'll go ahead and move right into the presentation of eminent domain. And hopefully, are you going to put it up on the screen or
No, I was just going to talk.
you're just going to talk? Okay.
So is part of this in open session and then part of this
Yes.
is, all right, so the video's on.
So this is kind of informational piece,
Yeah.
beginning just on eminent domain, how the process works, things like that. But any specific questions related, we'll go away to session.
Yes, that makes sense.
So, hi everybody, I'm Gary Cook. I am the county solicitor, is my official title. It's actually the county attorney. My office handles all the civil work for the county. We don't do the criminal work, that's done by the state's attorney's office. I have been with the county for about 10 years. I've had this role since 2015. Prior to that, I was in the Attorney General's office for the state of Maryland. And then before that, I was in private practice. I have been a trial lawyer for most of my life until I got this job. But I've handled condemnation cases both for the state as well as for the county. So Andrew asked me to kind of give you a very bird's eye view of the condemnation process. And then if you have any general questions just about what I've said or any other things that are maybe not specific to what you guys would hear about, then we can talk about that too. I think that's fair game. So let me start out by saying that both the county as well as the Board of Education have the power to condemn. So this is not strictly something that the county has, but the Board of Education by state law also has the power to condemn. And that's under educational role section, I just have it, 4-119. So everything that I'm saying about the process, at least in terms of what condemnation is, would apply equally to them as it would to the county. They have their own process about how the board would actually act to say, let's go condemn something, which is their own process, but in terms of how condemnation works, it would be the same. So I'll tell you from the county side, the way it works is, it's really not something that somebody thinks about as an initial matter. The county desires to acquire property, regardless of how that is, and that gets started by the creation of a capital project in the county's capital budget, because anything involving the expenditure of money has to flow through the county's budget. So you create a capital project because it's a capital acquisition, you're buying land, improved or unimproved. And once that authority to spend money exists, then the county executive is authorized by county law to go out and try and buy property that he or she feels is needed by the county for a public purpose, is basically the bottom line, the nomenclature. If a voluntary sale fails, price is too high, terms are just off, they can't agree, then if the desire is to continue to want to buy that particular piece of property, then what the county executive does is goes to the county council and says, we've already adopted a budget that wants to, acquire land for this purpose. I've identified this particular piece of property as the best suited for that purpose, but I can't negotiate a voluntary sale. Would you please authorize the Office of Law to condemn? So then it's in the county council's hands, and they consider a resolution authorizing my office to initiate a condemnation action in court on behalf of the county and the citizens of the county. And the issue there before the county council is limited to just the issue of necessity, and I'll talk about kind of big issues in a moment. Assuming the county council agrees, they pass a resolution. The legislative process at a minimum takes about 40 days. The budget process is the better part of give or take, sort of starts in earnest in the fall of the year, and the county council passes the budget in May of the following year. So you're talking about roughly a 9-month process, just from the budgetary standpoint, which is what kickstarts it. So we file a suit against the landowner to acquire the property, and that gets litigated in court. The circuit court schedule for a condemnation is about a year, and then if the parties don't settle the case, but actually you're going to try the case before a jury, then you have to wait to get a jury trial. And because of you've heard a lot about the courthouse, because of the physical space constraints over there, getting a trial date, get a jury in a box, it can take a while. So you might wait for a trial date, and then we'll try the case, and we'll talk about what the issues are in that in a second. And then assuming someone's unhappy, then it gets appealed, and the appeal process will take at least another year. And if it goes to the highest court in the state, then it would take another year after that. And assuming that it doesn't have to come back down and get retried, which oftentimes can happen, then you're talking about 3 years or so being tied up in the courts. That's worst case scenario. Actually, worst case scenario would be even longer if they come back and try the case again. So the issues with condemnation are basically there's three big picture issues. One is there has to be a public purpose for acquiring private property. Okay, public school, it's pretty clear that's a public purpose, so that's a pretty easy thing to satisfy. Necessity is a requirement that looks at whether at the time the decision is made, did the decision makers, in this case, county executive and county council together collectively, they reasonably believe that this acquisition is necessary for a public purpose, right? So that is typically a very easy test to satisfy. The courts usually don't disturb those kinds of decisions unless there's like fraud or just like ill intent, which usually is not the case, thankfully. And then the last issue is just compensation. The government may take your property if it needs it for a public purpose that's needed to be satisfied, but it can't do so without first paying for it. And oftentimes that's where things will break down, is that people have one idea of what their property is worth, because the owners typically have a huge emotional attachment. Not always. I mean, if you have a commercial entity, they may have a profit-oriented or a logistical or a practical reason why they want property in a particular spot as opposed to another, but there's not that emotional tie. And people tend to put value on property based on emotions, which the marketplace doesn't recognize, because the standard is basically fair market value. So, right, a willing buyer, a willing seller, nobody's forced to sell. What's the best use I can make of this property? And that's kind of this mushy legal standard that the court applies and instructs the jury on. And the jury decides how much the property is worth. Enters a judgment against the landowner, and as soon as the government pays for the land, transfer titles to the government, all paperwork gets straightened out. So that's kind of the big picture. So public purpose, necessity, and then just compensation. Those are the three issues that are in any condemnation case. Whether, I told Renee, I told him that the board also has the power to condemn Robert. So I was saying that necessity, purpose, and just compensation are all part of the process if the board were to do it. And if the board were to do it, once they decide to do it, then they would have to put in their budget request to the county, because the county funds the Board of Education's budget. That we've got this judgment that we have to pay. You know, we either know it's X, or we've got a pretty good idea that the evidence is going to support a judgment up to X. And so they would put that in their budget request, which you know, would need to be funded unless the powers that be decide not to do it. But that would be a pretty interesting scenario. So that's kind of condemnation in a nutshell. I mean, it's a extremely complex and involved, you know, area of law, like all areas of law. I mean, that's basically the big picture.
So I had just, I think I understood what you said, but I had
Yes.
just a clarifying question. So when the Office of Law would initiate the process, you would not be setting what you think is just compensation. That waits for the jury, is that right? Or is there an initial thing in your first pleading that identifies what you think is just compensation?
Mm-hmm. No, the constitutional standard is they're entitled to just compensation. By that point in time, the county has a very clear idea of what it believes is just compensation,
Right.
based on appraisals and all that other stuff. It's just the other side that disagrees, and so, no, but that's not an express part of the complaint. It's just they're entitled to get that, and they are.
Right.
Property owners are entitled to that. So yeah, the parties they'll put on experts and what have you, and the owner's entitled to testify to as to what he or she or it thinks is the appropriate value for the property. It's given as much weight as the jury decides to give it. They may say that's pie in the sky, or yeah, that's sort of like in line with what the appraisers are saying. You know, so,
Do unique aspects of a property come into play at all? Like if there's some aspect of the land or the property that could not be replaced, you know, elsewhere or nearby, is that part of the assessment of how the value of the property, or are there certain like unique aspects of the property that they could argue,
well,
you know, that there's nowhere else basically that has
yes.
what this property has?
That could be true. That's true of every piece of property. In the law, every piece of property is unique. It has its own characteristics that aren't found anyplace else except that parcel. So it's actually not so much a legal question as it is an appraiser's question. Appraisers do, I mean, it's this whole specialty. You know, licensed appraisers can try and take those factors into account when it's appropriate to do so. But again, it's a willing seller and a willing buyer for the highest and best use of the property. So those features may matter in a particular set of circumstances, but they also may not in another. And so I don't really see there's a hard and fast rule on it. But it's an appraiser. If it can be valued, it would be done by an appraiser. And whether a piece of property has such a feature is primarily an appraiser's kind of question.
But then it becomes a monetary comparison as opposed to a features comparison. Because a
It's
property
always about the money.
right, but a $1 million property because of XYZ features could easily be replaced by an equally valued $1 million property without those XYZ features, since it boils down to dollars.
Run that one by me again.
Well, what she brought up was if it has some feature to the property,
A physical feature to the
physical
property.
feature to the
Not
property,
an improvement.
not necessarily an
Like
improvement,
a vista. You
Yeah,
see the Grand
vista
Canyon.
or-
Okay.
yeah. to that effect.
It's gonna be a park.
That cannot be, right, I know, it cannot be replicated elsewhere, but if it gets appraised and it's appraised for X dollars, then the replacement would just be something else that appraises for X dollars regardless of the features. Yes, no?
Well, I'm not sure what, I think that's where you lock it, the idea of replacement. The idea would be, if there's evidence that that feature has a monetary value, and there's support for it before the jury could decide to award a damages award that takes into account the value that it believes that feature
As
should
should
have.
Okay.
But I think where you lost me was the.
Yeah, no, I know, I'm thinking, comparing two different properties, but.
No.
Well, and I think, since you said it's based on a willing buyer and willing seller, the reasons that the seller might not be willing don't really play in, right? Like the reason, if the seller doesn't want to sell because they want the view of the Grand Canyon, the view of the Grand Canyon is part of the value, but the fact that they can't replace it with another view of the Grand Canyon is not a factor, right?
Correct. You're valuing the land that the government wishes to take.
Right.
So
What they can do with.
some things may have an objective market-based value. Well, let's just assume that it is the Vista.
Yeah.
Maybe, I don't know, I'm not an
Yeah.
appraiser. But, because, my favorite dog was born in a barn, right at the end of the
Yeah,
lane.
that doesn't happen.
I mean, that has a value to it, to the owner of that property at that time, but, I don't know you're gonna get compensation
Right,
for
yeah,
that
monetized.
marketplace.
Right.
Yeah.
What about zoning? Like, let's say the zoning has changed on a piece of property, but yet, does that play a factor?
Well, appraisers take into account what the property is currently zoned for, right? But zoning can always be changed. I shouldn't say that. There is a process for changing zoning. Whether that process results in zoning change is always, a roll of the dice. But when appraising a piece of property, definitely the zoning is taken into account because that gets into highest and best use, right? Yeah, because you can only do with the property what the zoning allows to be done with it.
Right.
Yeah. Right. So it does influence the appraiser, because then the appraiser starts looking at comparably zoned property, similar uses of that property, and starts to make some hopefully roughly apples to apples comparisons. There's a lot of, as you can imagine, there's a lot of subjective judgment calls made even by the appraisers. They try and objectify it and minimize the amount of the subjectivity as much as possible. But one appraiser might look at two properties, and I've seen this a lot. You look at two properties, and that's a pretty apples to apples comparison. The other appraiser says, "Yeah, I'm not buying that. And my report has that. Here's our property we want to take, and I'm comparing it to this property over here because I think this is more of an apples to apples." So you do run into that.
The appraisers have to kind of justify what
They
their
do.
appraisal is, usually with comparables or,
Right.
track, history of comparable properties if there's nothing currently on the market.
It kind of boils down to a relationship, if you will.
Yeah.
You don't have a relationship with the appraiser. You have 6 people on the jury,
Uh-huh.
and they're going to likely believe one person more than another based on credibility. They like the person, don't like the person. Their report makes more sense to them. They have good responses to why they did things the way that they did. Maybe the other person not so much, and then trials are a very unwieldy and wild process.
In the event of a business situation, could it be argued that there would be some damages awarded for lost business if there are certain aspects of a property that a business would argue make it more valuable? So could that be considered or folded into the appraised value or onto what the jury decides is the ultimate?
But yeah, again, it depends. If there's a voluntary transaction, those, it is voluntary. But if the government actually forcing you off your property, then the state law does provide for certain relocation type of compensation. But like the case that comes to my mind is the ICC, the Intercounty Connector, right? So the government condemned a few properties. The state condemned property to create that road, and in the course of doing so, they had to relocate people. Pretty sure they had to relocate some businesses. But that's all pretty much, I don't want to say cookie cutter, but generally speaking, state law only provides for certain things to be compensated up to certain amounts. And those have all sort of survived challenge in terms of being constitutional. But it depends. A voluntary deal is a voluntary deal. Obviously, if you want to do it, you want to do it. If you don't want to do it and force the government to condemn, then yeah, you can claim damages for relocation expenses.
Just to give us a framework, how many unmentoring procedures have started forward like this year or the past 5 years? And how many were on properties that were larger than 10 acres?
Very few.
Very few this year or very few in like the past 5
Within
years?
that time frame and those figures, those acreages. Yeah, I'm speaking for the county now. I can't speak for the board, and I'm not speaking for the state. But most of the time, the parties work something out because nobody wants to go through the condemnation process. It's, like I said, people always threaten about going to court, but the reality is you give your fate over to a third party, 6 to be exact, maybe if you want to go to a judge in a 7. And you have no control over those people at all.
And you have to pay for that. Like,
You're at their mercy in terms of whether they believe your appraiser or not.
So that's the question, if you would go to take a piece of land for condemnation, you owe their fair market value. If the other party loses, do we pay their legal bills, or do they have to pay their own legal bills?
Yeah, that's a good question. I believe that there is a cost-shifting mechanism in the state statute. And I have to apologize, but I don't remember whether it's all cases, right? Because ordinarily, the lawyer gets paid out of compensation paid by the government. But I do think that there may be a provision for shifting costs back on the government in the event that the property owner were to prevail. Yeah. It's very rare when the government loses a condemnation case. Very rare. Especially in this, kind of like a road, a school, those are clearly public facilities.
Right.
And like I said, need is not something that is terribly onerous to show. And then it just really comes down to money.
Yeah.
That's the only other element that you're talking about at that point. Yeah. So, back to your question. I think within, it was 5 years, right? So in the last 5 years, the county has conducted one condemnation case. It was for a sewer easement. It was only because when the land got subdivided back in the late 50s and 60s, the surveyor screwed it up. Excuse me. The surveyor made a mistake. The private surveyor made a mistake in terms of how the land was described, and so ownership of the property was actually in a deceased person's estate. So there was no way to negotiate with a deceased person or their personal representatives. It came and went a long time ago. So it was just easier to condemn. But that was, I don't even remember how much we paid on that. It's just an easement, so I think it was less than $20,000 or something like that. I don't know what higher. I don't really remember, to be honest with you. But nobody likes to use the power, generally speaking, because it just sort of seems like, it's heavy-handed. But if you have a project that's worthy, like you're building a road, and there's general agreement that the road needs to be there, and you've got some real holdouts. I mean, Route 175 is a great example of that. There's a lady who owned the property right across from where the new park is, where it's big, still under development. And she held out forever. And the state finally said, we can't negotiate with you anymore. And so they ended up, then it was a really long drawn out process. And nobody likes the way
She never cashed the check.
Yeah, I don't even know if she ever cashed a check.
She
She was a bit of center.
She did not, she never cashed the check.
Right, yeah.
And actually, she owned both sides of 175.
Right.
Where the park is and the other side, she owned all that.
Yeah.
That's just, yeah.
Yeah, right. So, anyway, it's, most of the time it gets worked out where the parties agree. Yeah. Prior to that, I couldn't tell you, because somebody else was handling it back then. The last time there was a lot of condemnation activity was when Route 100 was extended from, I guess, was it 95 to 29? Or was it 1 or something? But wherever, yeah, let's say 95 or 29. In fact, there's still some property for sale if you want to buy. I don't want to wait and, 100 states had it on the market for like at least the last, how many ever decades.
Because they thought they needed it and decided.
Exactly what happens. They chew off a little bit more. Well, they think they need it, but then as it turns out, engineering changes happen or whatever, and all of a sudden they don't need it anymore. Like this weird shape thing next to an on-ramp. And it's kind of hard
We
to
want to
blow.
let that. And I should say one thing. I'm not speaking for anybody. So when I said people don't like to use the condemnation power, I don't want people to take away from that. But like the county executive or the county council wouldn't do it. I had no idea. We don't like it either.
I don't have any idea. It's just that every time the topic comes up, there's like this collective groan or whatever.
Yes. Yeah.
So I'm channeling that. I'm not channeling any specific voice in my head that's saying.
And that's why we have you here, is because I think it's important, I believe, the other members of the task force, that there's rumors that swirl around and things around them. I mean, it's good to have the facts in front of you. Even if sometimes it's not nice facts or feel good, it's good to have all that put out. So you're not, taking this and throwing it into a room, I don't know what your preconceived notion
It also seems like it's not what they prefer to do because it's not the most effective tool. It's by definition drawn out.
Litigation
It's
is
more
never an
expensive.
effective tool.
We're trying to be, effective stewards with the county's money, get the land quickly, build the school quickly. When you're on it, you're going to throw a 4-year break on the process by doing eminent domain. Right. It's really kind of counterproductive.
Yeah, I mean, most lawyers would tell you that if you're ending up in court, it's basically been a failure.
Yeah.
And you're stuck giving it to somebody else to try and figure it out.
Right.
Yeah.
Okay. That's the impression I had.
Yeah.
is. That's been very
Sure.
Thank you.
Any questions? Okay, so what we're going to be doing now is moving into closed session to discuss and confirm the properties that we recommended. So, anybody want to put a motion for to move into closed session?
And are we, just as I'm looking at the agenda, we're also going to be talking about sort of how we can put potentially confidential things in a recommendation. We're going to do a task on the right. So I move to go to closed session for those purposes.
Okay.
I'll second it.
Second. All right.
So the record should be really clear the grounds that you're going into closed session on, because those are the only areas that you can discuss when you're in closed session. So you should probably make sure that those are part of the record. So what are the grounds that we're going in closed session?
The grounds are section 7, to consult with counsel to obtain legal advice. Section 3, to consider the acquisition of real property for a public purpose and matters directly related thereto. And section 13, to comply with a specific constitutional, statutory, or judicially imposed requirement that prevents public disclosures about a particular proceeding or matter.
All right, all in favor?
I,
Right.
So based on our discussions in closed session, it is clear we're going to have to meet again. And we are not yet at a point where we are drafting a final report. We still need to thoroughly consider the properties we have identified to be in this report.
Correct. And we will go ahead, I can email everybody throughout some dates, because it's just now the beginning of August, and hopefully we can meet again, or as many people as we can meet, and we can meet in closed session to discuss these properties, compare them against the reversion. Some sort of an outline draft put together so we can have a draft by the September 11th meeting for all of us to look over and make necessary changes. We get whatever we need to do. So hopefully by the October meeting, which is October 1st, we'll be able to submit some sort of a recommendation to the county executive. That sounds good?
Yeah.
All right. Any other questions before we close?
Move to adjourn?
Move to adjourn.
Second.
All right, all in favor?
Aye.
All right, the meeting is adjourned. Thank you, everyone.